Ladies and gentlemen, please welcome our esteemed moderator, the Honorable Ryan Nelson.
Well, good afternoon. Thank you for joining us for our panel of Foreign Free Speech Rights at the Water's Edge. A very timely panel and one that really is worthy of discussion. And so we've got a great group of panelists that are going to kick that off today. First, we'll hear from Eugene Volokh, who is the Thomas Seibel Senior Fellow at the Hoover Institution. And then we'll hear from Timothy Zick, who is the John Marshall Professor of Government and Citizenship at the William and Mary Law School. And then we'll hear from Michael Adams, Secretary of State of the Commonwealth of Kentucky. And we'll hear some remarks then from Robert Kellner, who is chair of Covington and Burling's Election and Political Law Practice Group. So we'll turn it over to Eugene.
Thank you. Is this on? Push. All right. I very much appreciate the invitation to be on this panel. Always a pleasure to talk to the Federalist Society. Always a pleasure to talk about free speech. This is a topic I'm particularly interested in because I think it's so complicated in a way that many of us don't really notice. I hadn't before I started looking at it more closely. Don't know what the right answer is, but I do think it's helpful to look at it, to look at a bunch of things that are raised within it together, because it turns out that this issue comes up in a lot of different contexts, and it's hard to know how it should come out in any of them, much less all of them. So let me start. Why is the clicker not clicking? There you go. All right, good. Let me start by just listing a few issues. I wonder if I need to be pointing. Where do I need to be pointing? Does anybody know? Okay. So we saw this most recently with the TikTok divestment mandate, right? That if the government were to say, you know, we insist on Facebook being sold to someone else because we don't like Mark Zuckerberg, I think we'd say, well, that's not what the government is entitled to do. Certainly couldn't do that with the New York Times, let's say. But with TikTok, the sense was, and of course the sense ultimately was, that there is something different about speech that is in some measure, or speech platform that is in some measure under the influence of a foreign government, although the exact extent of the influence was, of course, contested. There's also an important currently pending issue on deporting foreign students for their speech. Tim, I think you'll be talking about it extensively, but obviously that's a tremendously important question. Obviously not the same question as number one, but you think there's an interesting connection, right? To the extent that you can punish students for their speech, presumably it's because of the foreignness. And why, or even if you don't view deportation as punishment, it is in effect very similar to it. What about restrictions on speech related to elections by permanent residents? There's a case right now in Ohio. There was just a decision from the Sixth Circuit on that. The Supreme Court has said that spending related to elections, which of course is protected by the First Amendment under Buckley v. Vallejo and under Citizens United, can be restricted for non-permanent resident aliens. What about permanent residents? That's an important question. Well, what about partly foreign-owned companies? Which is to say, pretty much all publicly owned corporations are probably partly foreign-owned. If their shares are sold on the stock market, we may not even know to what extent they're foreign-owned. Some of them may be quite substantially foreign-owned. Some of them may be quite substantially foreign-owned by a foreign government. Some of them may be foreign-controlled, and their CEO may be a foreigner. Many corporations perfectly willing to hire foreigners as CEOs if they think that this person is going to do a particularly good job. Well, to what extent should we be worried about that corporation spending money on elections? Just to give another example of a very minor matter, but something that came up in, I think, the 2016 campaign, then candidate Trump, his campaign received a position research related to Hillary Clinton from foreigners. And at least one of my colleagues says, well, that's a violation of federal law because that is accepting a donation from a foreigner to a campaign. That didn't seem quite right to me, but it just shows how attempts to restrict foreign influence on American campaigns, how broad they can be. And then, of course, something we aren't talking about much, but certainly the money is pretty big, is possible restrictions on universities getting grants from foreign countries. China, Qatar, maybe others. Here is a list from a site called The Corruption of the American Mind. I'm not sure I endorse the title, I'm just quoting it there. But the data seems accurate. So American universities got over $2 billion in 5 years from Qatar. Although $1.4 billion from England, over $1 billion from China, less than $1 billion in Saudi Arabia. Bermuda is the real puzzle. Presumably it's some shell company that's in Bermuda. Nothing necessarily sinister about it. Lots of places incorporate in Bermuda, Liechtenstein, Delaware, other places where they're not fundamentally doing business. So let's say the government were to say, we don't like the universities taking foreign money or foreign money from a particular country. Can it prohibit that? We know from Buckley v. Vallejo that restrictions on spending money on speech are treated as restrictions on speech because practically they are. What should we think about that? Now, the Supreme Court has held quite early on in the history of First Amendment law that freedom of speech and of the press is accorded to aliens residing in this country. So somebody can't be imprisoned or fined or sued for speech that would be protected for a citizen just because he's an alien. It is also held that citizens have a right to hear alien speech. And not just alien speech, but foreign government speech. And not just foreign government speech, but adversary foreign government speech. This was in a case called Lamont v. Postmaster General in 1965, where the Supreme Court struck down a restriction on the receipt of foreign propaganda from foreign governments. At the same time, when it comes to speech to foreign terrorist organizations, the Supreme Court has said that it can indeed be criminalized. And I'm talking just about speech. This is the material support statute. But in addition to supporting a foreign terrorist organization by providing money or providing arms, let's say, the Supreme Court said it extends to providing it information or training on use of international legal organizations and the like. And the court says, well, that law is constitutionally permissible. What about speech in league with a foreign government? The Supreme Court has never talked about that, but immediately following World War II, there were prosecutions of essentially American citizens who had participated in foreign propaganda. And Axis propaganda. The shop window example is Tokyo Rose. Actually, turns out, I think she was ultimately maybe pardoned and such because there was evidence that she did what she did under duress. That's just it's a criminal law matter. But Chandler and Gillers, who were involved with the Germans, were punished. And punished simply for speaking under control of the Nazi government. Seems to me perfectly sound. Foreign armies operate through shooting and through propaganda. And if you're in league with the foreign army, if you're actually conspiring with them, surely you ought to be punishable for that. But it is an important and interesting data point. Likewise, when it comes to speech for foreign governments, on behalf of foreign governments, the Foreign Agent Registration Act does not prohibit such speech, but requires a registration in a way that, of course, would be generally at least constitutionally suspect in the absence of the foreign government. What about foreign ownership of media? So there's a federal statute that says broadcasters can't be owned by foreign governments, by aliens, by foreign corporations, or corporations with more than 20% foreign ownership. That's never been considered by the Supreme Court, but at least there's a congressional judgment and kind of a long standing about that. Note there's no such limit on newspapers, and I do think it would be an interesting question if, let's say, well, how about Rupert Murdoch, right? Who I certainly was for a long time not an American citizen, may not be an American citizen. I believe he's Australian, if I'm correct. But you could imagine if not him, somebody else. Somebody says, you want to buy a newspaper? No, you're a foreigner. That seems at least a little contrary to our traditions, especially if you then go around with regard to books. Imagine you say we can't have foreign-owned book publishers. TikTok v. Garland, though, said essentially that it is permissible to restrict the, foreign ownership of social media platforms, at least when the concern is privacy. There was a separate concern of foreign influence over the algorithms, which the D.C. Circuit embraced, but the court said we don't have to reach. What about speech and immigration law? I'm going to only just foreshadow what Tim is going to be talking about, but there is in fact a federal statute which makes it, again, I don't know where I should be pointing this to, essentially makes says aliens must be excluded and may be deported for endorsing or espousing terrorist activity. But no, terrorist activity is defined very broadly. It is defined to include basically any sort of political violence here or abroad. So if somebody says, oh, I think that all good patriotic North Koreans should try their hardest to assassinate Kim Jong-un, some of us would say, well, that's probably a good idea. But if that person is a foreigner, let's say a South Korean citizen, then they could in principle be deported for saying that. Actually, so I'm sorry, I'm just going to keep forwarding rather than trying to go back again. Something kinky with this clicker. So it's not just the Trump administration, it's also Congress that imposed that kind of restriction. Although the Trump administration's recent deportations actually aren't limited to even that pretty broad statute. There are situations where they're just saying we're deporting someone because their speech is contrary to our national interest, even without any showing that there's a violation of the statute. What does the law say? Well, would-be entrants may be excluded based on their speech. The Supreme Court has held that, more or less, I oversimplify, in 1972. Aliens being deported generally can't raise selective persecution claims. The court held that in 1999. But what about just deportation? Well, some cases say that, for example, immigrants may be denied citizenship based on their speech and, in fact, may be deported. I don't know what's going on here. In any event, but there's a circuit split on the subject. I'm sorry, what's going on? Thank you. All right. Let me, just because time is running short, let me close with a few remarks. So one is, I do think this right of listeners point that I mentioned earlier, that the Supreme Court accepted in Lamont v. Postmaster General, is a very important point. We might say, look, First Amendment is fundamentally should be seen as a political right. It's for members of the political community, maybe lawful permanent residents, maybe not even them, maybe just citizens. But we as citizens also have an interest in hearing things, and it's hard to understand international problems without speech by foreigners, including foreign companies and foreign governments. It's an odd fact that's easy to forget, that 96% of the world consists of foreigners. Shocking, but true. So just to give an example, in a university, what do class discussions become when the non-citizen students, of whom there may be many, and who may actually contribute a lot of interesting knowledge and information and opinion to debates, know they can be deported for their speech? Again, even if you say, well, we don't care about their rights because they're guests here, they're visitors. What about the rights of the citizen teacher? What about the rights of citizen fellow students who want to have a discussion that is not abbreviated, is not truncated because some of the members, some of the participants are afraid of being deported? Second thing I want to observe is what I call the frenemy problem. Imagine we were restricting companies that have business relations with German organizations during World War II. Very few speakers would be affected because they were clearly our enemy. Nobody would be having these kinds of business relations. What about restricting companies that have business relations with Soviet organizations during the Cold War? Probably wouldn't be treason to have those kinds of relations. It would just be very bad business because the Soviets didn't know how to do good business. There was no Soviet analog to TikTok because they were really bad at creating consumer-friendly technology. But now, when we're restricting companies that have business relations with Chinese organizations today, many speakers may be affected. right? Likewise, there probably are companies with significant Chinese ownership, as well as ownership by, let's say, Saudis, Qatar, less clearly our enemies, but let's say still adversaries in a certain way. But the FRA is important too, because there are a lot more American speech might be implicated by restricting the foreigner speech. So what do we say about that? So there's a line that I remember reading in an article of Banking Law, of all things. Any Anglo-American lawyer must cope with a sneaking feeling that there's no such thing as first principles, just one damned case after another. So that may be your reaction after seeing that list of cases. I hope you agree that all of them have something in common. But what is the logical through line that should yield a clear rule? Don't know. Or maybe you might say foreigners or foreigner-related speech is less protected when it's related to sovereignty or enemies or, say, major foreign influence opportunities, like with broadcasters or TikTok. Maybe that would explain things, maybe. Or maybe it's really a matter of congressional discretion, just less protected, period, whenever Congress so decides. Or maybe you might say, in part because you think of free speech as a universal right and not just an American political right, or because you focus on rights of listeners, that all of these restrictions are at least highly suspect and should presumptively and maybe even conclusively be restricted. I don't know the answer. If you know the answer, let me know, because I'm writing an article. I will give you full credit. But that's what I've got for you.
Professor Zick?
Well, thank you. This is my first Federalist Society conference, so I'm happy to be here. I'm very interested in this issue, have been for a long time, the speech rights of non-citizens, and I want to thank the organizers and to thank everyone I've interacted with for your hospitality. As Eugene says, these are complicated issues. I'm not going to pretend otherwise. I'm not going to, in my remarks, say I have a clear answer to the questions that he raises. I'll talk about a few of the things that he did already cover, but I'm going to frame my remarks through AAUP versus Rubio. Many of you are probably familiar with the case. I'm going to give a brief description of it because my time is short, and then talk about some reasons I think to be skeptical of what I'll call First Amendment exceptionalism in the immigration area, by which I mean the position that either the First Amendment doesn't apply at all to non-citizen speech, or if it applies in some very watered-down version. So in terms of brief description, AAUP versus Rubio is a case brought by two educational institutions and their members and their chapters that allege that the Trump administration had implemented what they called an ideological deportation policy, that they had targeted people for pro-Palestinian or anti-Israeli speech, and arrested and detained and subjected to removal those individuals. It turned out that the policy was applied almost exclusively to international students and foreign scholars in the United States, either on green cards or, in most cases, temporary visas. There was a 9-day trial before Judge William Young in Boston. He heard from 15 witnesses, took in 250 exhibits, and then concluded that the plaintiffs would prevail. The plaintiffs' claim, by the way, was that their First Amendment rights had been chilled by this so-called ideological deportation policy. So that was the basis for their First Amendment claim, and the judge ruled in their favor. Because I have nothing better to do in July, I attended all 9 days virtually, because the judge made that opportunity available. And I've been thinking about the testimony in the case and the judge's ruling. He made extensive findings of fact to Judge Young, and I can't go through nearly all of them, but I wanted to highlight just a few. President Trump had issued 2 executive orders with respect to the executive policy on vigorously combating anti-Semitism. One of those orders directed federal agencies to arrest and deport lawfully admitted aliens who, according to the executive order, quote, bear hostile attitudes toward American citizens, culture, government, institutions, or founding principles, or advocate for, aid, or support designated foreign terrorists and other threats to our national security. To implement those orders, a White House task force directed the Department of Homeland Security Office of Intelligence to focus in particular on student protesters. So that came from the White House to the Department of Homeland Security to focus on them and develop reports of analysis with respect to their activities, organizing or participating in protests or engaging in other types of campus activism. DHS officials and State Department officials then did that, implementing, unfortunately without any guidance. So the officials didn't get any guidance with respect to what was anti-Semitism, for example, what constituted pro-Hamas speech. And so the judge found, as a result, the officials were using what he characterized as an elastic standard for those things. So in many cases, speech that was critical of Israel was equated with speech that was supporting Hamas. And the DHS officials concluded that the students had, quote, sided with terrorists, close quote, or engaged in anti-Semitic activities, although there was no evidence, at least in this case, with respect to the individuals involved, that they were actually linked to any terrorist organization. So the officials were focused on speech activities mostly. They were looking at conduct, of course, but what they found mostly was organizing protests. And in one case involving a student, I think at Tufts, she had written an op-ed and published it in the student newspaper. It's still there today. And that was the sole basis on which it was recommended that her visa, she was on a temporary visa, be revoked. As I said, the court made rulings of law as well. On the central question, do non-citizens have the same First Amendment rights? This is how he characterized it, the same First Amendment rights as citizens. Judge Young said unequivocally, quoting him, unequivocally, yes, they do. No law means no law. No one's freedom of speech is unlimited, of course, but these limits are the same for both citizens and non-citizens alike, close quote. He did conclude the federal government did not have a general policy of going after pro-Palestine speakers who were here on visas or green cards. He said, though, he concluded that the government's intent was, quote, more invidious to target a few international students for speaking out and then to very publicly deport them with the goal of tamping down pro-Palestinian student protests and terrorizing, his word, similarly situated non-citizens and other pro-Palestinians into silence because their views were unwelcome. So just a few highlights from the findings and the rulings that the judge made. During the litigation, the government was initially reluctant to take a position at all as to whether non-citizens had First Amendment rights or what their scope would be, but it eventually landed on sort of a plenary power over immigration position, effectively saying to the court, these decisions on visa revocations are judicially unreviewable, or at most, the court should simply ask whether there was a facially legitimate bona fide reason for the revocation of a person's visa, or in one case at least, a green card. So that's what I mean by First Amendment exceptionalism. That standard, if it were to apply to the non-citizen speech, including their political speech, which is what's at issue in AAUP versus Rubio, I think there are several reasons to be skeptical of that or to be concerned about it, some of which Eugene covered in his remarks, so I won't go into as much detail as I was intending to. But one is that exceptionalism, as I'm describing it, is just inconsistent with First Amendment principles, very broad First Amendment principles. There is a huge discrepancy between the McCarthy-era decisions on immigration and free speech, which do support the government's position, and modern principles that undergird contemporary First Amendment doctrine and law. The speech at issue here, what the court was dealing with was, let's say, core political speech, which ordinarily gets robust protection. We have a national policy in favor of robust discussion of public issues. The Supreme Court described that as a long tradition of wide open, robust, and uninhibited public discourse. And to sustain that tradition, generally speaking, the government can't discriminate based on the viewpoint of speakers. But the record in this case showed that that is precisely what government officials were doing. And having watched their testimony, I fully agree with Judge Young. They were acting in good faith. I don't think any of them were doing other than what they thought was their job as instructed. But the fact of the matter is they were applying sort of individual standards that imported biases they had. One of the consular officials, just under Secretary of State Rubio, testified that anyone who criticized Israel but claimed not to be an anti-Semite was effectively lying, that they were engaged in a dodge. That's how he testified. So meaning any criticism of Israel was necessarily anti-Semitic speech, supporting that country's enemies. And again, that official, I think, was acting in good faith without any guidance. No one had told him what standard to apply to visa revocations, which put the officials, I think, in a very tough spot. Nevertheless, the logic of the government's position in the case would be that the federal government could immediately revoke the visa of any person, any non-citizen, who said something the government didn't like, uttered a viewpoint the government disfavored. So there are those broad principles. There are First Amendment values at issue here as well, and Eugene touched on those. Non-citizens can't vote in state or federal elections. They can't hold office, but that doesn't mean their speech cannot help facilitate self-government. One of the principal justifications for having freedom of speech is that it is useful, in particular to audiences, to process information that helps them cast an informed ballot. Alexander Michaeljohn, who's credited with recognizing that core First Amendment value, said this about non-citizen speech, quote, "Unhindered expression must be open to non-citizens, to resident aliens, to writers and speakers of other nations, to anyone, past or present, who has something to say, which may have significance for a citizen who is thinking of the welfare of the nation." So it's not as if we're talking only about the speech of non-citizens, it's also citizens' interest in receiving information. And if you think about another justification for free speech, it's that it contributes to debate in so-called marketplaces of ideas. Well, those marketplaces cross borders, and those marketplaces involve non-citizens, even here on U.S. soil, whether it's in classrooms or workplaces or private associations or town hall meetings. Those exchanges occur. They are of value not only to the speaker, but again to the audiences who are hearing the speech. Another reason to be concerned or skeptical of First Amendment exceptionalism is that it can generally chill expression. That was the plaintiff's claim. Again, not that they were subject to deportation, but that they were concerned if they said something the government did not like, they would suffer that fate. And Judge Young found, one of his findings was the government's actions, quote, "created a climate of repression and fear on university campuses such that some non-citizen students and faculty have stopped attending protests, resigned from politically oriented groups, and in general now hesitate to speak on political issues in public or even in private text messages." As of 2024, there were more than 1 million international students studying in the United States and a great many foreign scholars. Their expression may also be chilled by a policy like the one being challenged in AAUP versus Rubio. But I would say the concern about chill extends beyond those individuals or those groups. It extends to all of us, all citizens, who, if we believe the government has the power to punish someone for uttering a disfavored viewpoint, we may fear, even for ourselves, what may come from engaging in that activity. Exceptionalism, as I'm describing it, threatens academic freedom. That's mostly what AAUP versus Rubio is about. These were researchers and scholars and students who claimed they did not any longer feel comfortable engaging in academic freedom-related activities. So one person testified that she, quote, "canceled overseas trips, shied away from writing on certain topics critical of Israeli policies, including ceasing development of a specific article that was to discuss Hamas and Israel." And other plaintiffs testified that they were chilled in their classroom discussions and contributions to public discourse. So the threat there extends, again, not just to non-citizens, but to citizens, because if you were working on a research project with a foreign scholar or a student studying on a visa, you too may be concerned about what you can research and what you can write about, even if you are a citizen. Exceptionalism treats freedom of speech as a privilege and not a right. That too is inconsistent with our values and our principles in terms of the First Amendment. Here's what Secretary Rubio said in one of his appearances, quote, "This is not about free speech. This is about people that don't have a right to be in the United States to begin with. No one has a right to a student visa." And he's right. No one has a right to a student visa, but under an unconstitutional conditions principle, the government can't punish you for speech with respect to the receipt of that benefit. It can't say that you can have the benefit if you relinquish your right to free speech. That's the ordinary rule, and we could abandon it. We could just apply the right-privilege distinction, which has otherwise been discredited every place else, just to this particular context. But I would be concerned that we wouldn't be able to contain it to just this context, and I think that would be a very bad thing for freedom of speech more generally. And one last point, just attending the trial and sort of listening to the testimony and reading the judge's findings of fact and rulings of law, there's some very serious due process and rule of law issues with respect to the implementation of the policy that was challenged in AEUP versus Rubio. Again, the directive from the White House was to target a very small class of individuals, protesters, who were engaged in a lawful speech according to First Amendment standards, and to arrest, detain, in some cases to transport from the places they lived to places like Louisiana, and to hold them for weeks, maybe months, because of what they said. And as the government is trying to apply whatever standards that they think federal law command, they're relying on, as I said, some of their own biases about the speech. They're relying on overbroad definitions of incitement or terrorism or anti-Semitism. And one last point about that sort of due process issues here. It's not possible to say that the student, when she wrote the op-ed and published it, or the students who were engaged in the protests, knew at that time that what they were doing would subject them to arrest, detention, and deportation. Ordinarily, you have to know in advance what the standards are for your speech if you may be subject to punishment. So I think the case, just to sum up, highlights, for me anyway, some pretty compelling reasons not to treat the McCarthy era as a model for current or modern First Amendment interpretation in the immigration context, but to treat it as an aberration. Thank you.
Secretary Adams.
Thank you. Good afternoon. Good afternoon. Today I'd like to discuss current efforts to preserve both our freedoms and our sovereignty. From the tone of today's media coverage, you might think there's a new wave of xenophobia overtaking us, as though only in the last 10 years did we start to care about foreign influence in our affairs. But from day one, our Constitution has required members of Congress and the President to be American citizens. Indeed, the President must be a natural-born citizen. It is true that it was not until 1996 that federal law was amended to clearly state that non-citizens cannot vote in federal elections. But many state constitutions had already reserved the right to vote for citizens. To remove all doubt, recently, my state of Kentucky, and many whose constitutions use language similar to ours, amended our constitutions to say, instead of citizens can vote, only citizens can vote. 7 states did so in 2024, and in the 2026 election cycle, more states will take it up. For decades, and arguably longer, we have taken election integrity for granted, both overall and as to non-citizen voting. I, for one, am glad that now we take these issues more seriously. I say that out of principle, but also out of selfishness, as were it not for making my campaign's referenda on election integrity, I wouldn't be the Secretary of State. However, I'd like to put these issues into perspective. I'm against a non-citizen voting in a U.S. election ever for any office under any circumstance. But to the extent this is a widespread problem, It pales before the influence in our elections that foreign actors play through other methods. Have millions or even thousands of Mexicans voted illegally in our elections in a concerted plot to elect sympathetic politicians who will influence our foreign policy in favor of Mexico? That is doubtful. Let's assume for the sake of argument that I'm wrong. Even if I am wrong about what has happened before, we've now improved both our laws and our processes to prevent non-citizen voting. Following improvement of our state constitutions and laws, my fellow secretaries of state and I are less vulnerable to litigation when we take non-citizens off our voter rolls and refer them for prosecution to our attorneys general. Also, after 4 years of non-cooperation at best from the federal government, now our calls are getting returned, and now our requests are being granted, such as now we have the ability to share our voter rolls with the U.S. Department of Homeland Security, which has superior information to ours as to individuals' citizenship status. The next step, I hope and expect, is to get similar access to the Social Security Master Death Index. If a registered Kentucky voter living in Kentucky passes away, I find that out pretty quickly and take that person off our rolls. If a registered Kentucky voter retires to California and passes away without having moved her registration to California, I don't find that out quickly, if I ever find it out at all. California is notoriously uncooperative when it comes to information sharing and voter rolls accuracy. I would like California to be compelled to cooperate. But short of that, I would like to get the information I need from another source, and I believe that with this administration, I will. Of greater concern to me, both given the relatively lower attention paid to it and the much larger potential impact it could have, is not non-citizen voting in our elections, but non-citizen influence of citizens voting in our elections. It is thoroughly documented by reliable sources, including Republican-controlled congressional committees, such as the Senate Committees on Homeland Security and Intelligence and the House Administration Committee, that our foreign adversaries quite cheaply, easily, and secretly attempt to influence our opinions and our decisions about political issues and candidates through propaganda. Franklin D. Roosevelt got a lot wrong, but one thing he got right was the Foreign Agent Registration Act. If you're trying to influence us and you're not one of us, show us your cards. Certainly, when it comes to First Amendment issues, rather than prohibition, sunlight is the best disinfectant. As we've seen over the past 15 years with the rise of independent political speech, it is better to legalize it than to drive it underground, because we all benefit from more speech and thus more interest in public affairs, and restricting citizens' ability to influence their government is rarely a good, let alone a constitutional idea. The question arises how to handle non-citizen funding of American political speech. Do we ban it or do we disclose it? Here I come down differently. I simply do not believe the more speech maxim applies when the additional speech is contrary to our national interest. Moreover, my concern about our constitutional rights being sacrificed to enable speech policing does not apply to those who may have rights in their countries, but not in ours. That is why I find the long-established ban on foreign national expenditures in elections of U.S. federal, state, and local officials to be satisfactory. But I believe this should be extended to elections beyond those for elected office. Only citizens should be able to vote in ballot referenda to, among other things, amend our state constitutions. This ban should be extended to non-citizen funding of campaigns for and against ballot referenda. For one, if we believe non-citizen funding distorts campaigns for elected office, the same logic should apply to elections for propositions and constitutional amendments. Second, elections on the latter usually are held during the elections on the former, and can goose the turnout and shape the debate in the former. If you're a wealthy non-citizen or a foreign country, investing in issue advocacy during an election of candidates for public office is the best deal in town. For this reason, other states should follow Kentucky and ban all foreign funding in campaigns for ballot measures. 31 states have not yet done this, and 6 of the 19 states that have done this have allowed indirect foreign contributions. Also, Congress should extend the ban on foreign money in our elections to contributions to 501c entities that permissibly may spend funds to influence elections for public office. Thanks, and I look forward to your questions and comments.
Rob, go ahead.
Thank you very much, and thank you to the Federalist Society for the invitation to be here today. I'm going to pick up on some of the themes that Mike just covered, focusing on FARA and on how our campaign finance laws treat speech and political activity by foreign nationals. Let me spend a minute explaining what FARA is and how it works, and we'll see if your eyes glaze over, which they may. And then I'm going to tell you why it is an awful, dangerous, easily weaponized statute that threatens free speech and should, in fact, be repealed. So that's a point where I'm going to disagree with Mike, who I think is a little bit more supportive of the objectives of FARA. For those who don't know, FARA is a very old statute enacted before World War II to make Americans serving as agents of the Nazi regime register and publicly disclose their activities. So for those of us who are not fans of Nazis, that seems a laudable purpose. But the statute really hasn't changed much since 1938. Many of its terms are clearly archaic and reflect the way propaganda worked in the prehistoric media days of 1938. And worst of all, for a criminal statute, the statute is hopelessly vague and broad. The statute says that if a foreign person, quote, requests that you do something for them in the United States, and you do it, you're an agent of that foreign principal. That is really so insanely broad that DOJ itself, just in the last few years, has tried to issue guidance establishing a complicated multi-factor test to figure out what that really means and to determine whether you are an agent of a foreign principal. We lawyers know how multi-factor tests work and usually don't work. So when DOJ reserves for itself the ability to decide whether you are or are not a foreign agent based on their own multi-factor, difficult to decipher test, and therefore whether you're a criminal for having failed to register with them and disclose your activities, the statute becomes a very effective political weapon that Republicans can use against Democrats or Democrats can use against Republicans. How it's used depends on the whim of a particular administration and the shifting sands of U.S. foreign policy. Who's in and who's out? You want to go after Israel? Use FARA against its friends in the U.S. Would you rather instead go after the Palestinians? Use FARA to go after their friends in the U.S. Hate China? Use FARA. Hate Taiwan instead? Use FARA. Mike suggested that it's a disclosure statute, but it's really more than that because I think of it as a gotcha statute that creates a predicate for criminal prosecution and therefore chills political speech by anyone who could be alleged to be speaking on behalf of another country or its interests. And ironically, if you do register as a foreign agent under FARA, that can be used against you too as a sanction, not just as a tool of disclosure. If you're a journalist, you might well be denied press credentials because you have registered as a foreign agent. And there are various journalists who have been denied press credentials in various fora because they were considered foreign agents or had so registered. You might be denied certain jobs, particularly certain government jobs, because you are a registered foreign agent. So it's not just in the real world about disclosure. So to truly protect free speech, this easily weaponized statute should be repealed, in my view. and foreigners should instead be subject to the same disclosure rules that we have for U.S. citizens who engage in lobbying or political activities in the United States. Now, I'm much more sympathetic to campaign finance rules that are intended to restrict non-U.S. citizen involvement in U.S. elections. There is not much evidence that foreigners voting in U.S. elections happens with any frequency at all. I think there have been far too many claims made to the effect that large numbers of non-U.S. citizens vote. They don't. That's just not the case. Where there has been a problem, though, over the years, it's been with non-U.S. citizens who pour foreign money into U.S. elections through political contributions in one way or another to influence the outcome of elections. By the way, I don't think there's any evidence they've ever actually affected the outcome of an election, but there has been a real problem with foreign money coming into our elections for decades. There have been numerous criminal cases over the years through Republican and Democratic administrations prosecuting foreign money in U.S. elections, going back to for those of you who are old enough to remember, the Buddhist nuns case under Clinton Gore. So it is a real problem, foreign money in U.S. elections, and that's why federal law is clear that non-citizens cannot make political contributions. Oddly, though, U.S. law does actually allow foreigners to volunteer their time and effort, and sometimes their valuable celebrity brand, even if they're not a green card holder, not a permanent resident, to influence our elections. In a whole series of advisory opinions, the Federal Election Commission has said that foreigners can donate their time to help campaigns. The most famous example was Elton John holding a concert for Hillary Clinton. The FEC said that was fine because it did not involve his spending money to support the campaign, and no foreign source was paying him to do it. Yet it was very valuable celebrity time for her campaign. In other opinions, the FEC said that foreigners can go door to door, canvassing for votes and do other kind of typical get out the vote activities in the United States. And again, because they were not giving the campaign money and they were not being paid to do it, it's deemed permissible for foreign nationals to do that in the United States, whether or not they have permanent resident status. That's why you recently saw, if you were paying attention, Jeremy Corbyn from the Labour Party in the UK campaigning for Mayor-elect Mamdani. You saw a left-wing Canadian member of parliament, also in the U.S., actively campaigning with and for Mayor-elect Mamdani. As long as they were not being paid by their political parties to do it, their expenses weren't being covered, and they weren't doing it on behalf of their political party, it's okay both with the FEC and probably also okay under FARA, by the way, if they could establish that they're doing it on their own and not as an agent of their foreign political party. So here I would go further, and I would actually ban, as a matter of policy and legislation, I would actually ban foreigners from all involvement in U.S. elections. The problem is that right now the restrictions flow from campaign finance law, so they're focused just on political contributions and political expenditures. But in my view, federal law should more broadly prohibit non-citizens from involvement in campaigns. I think the FEC probably correctly interpreted the Federal Election Campaign Act when Elton John allowed him to walk down the yellow brick road with Hillary Clinton. But as a matter of legislation, I think Congress could choose to expand the Federal Election Campaign Act to bar that kind of volunteer campaign activity by foreign nationals. I don't really see any good policy reason to allow foreign celebrities to be, or anyone else who's foreign, to be active in U.S. elections. And then briefly, a final issue is that current campaign finance law treats green card holders, permanent residents, essentially the same as U.S. citizens, meaning they can make political contributions. This is a cutting-edge issue right now in an important case in Ohio that was decided by the Sixth Circuit and is now on remand, last I checked. Ohio has a law, relatively new law, banning even permanent residents from making contributions in state elections. This is the Opal case. including banning their contributions with respect to ballot measure actions, ballot measure elections, both for green card holders and for visa holders. Thus far, the Sixth Circuit has upheld that Ohio law, which I agree with certain issues pending on remand, including the permissibility of extending that ban to green card holders making contributions in ballot elections, which are essentially legislative elections rather than candidate elections, so it's a slightly different issue. At the federal level, green card holders have been authorized by statute to contribute to federal campaigns, but it seems to me hard to defend the proposition that there should be a constitutional right for non-citizens to contribute in federal, state, or local U.S. elections, regardless of whether they have a green card. Thank you very much.
I thank the panelists for their comments. Rob, why don't I start a question with you? You were focused mostly on the campaign contributions and involvement in the campaign, and the bottom line was you thought FARA should just be repealed. I'd be interested if you take a broader view of this. Secretary Adams mentioned that we have foreign nationals that are getting involved, maybe not even in influencing an election, but in making our discussion in the United States more divisive. I think they're helping to divide the country. To the extent that that is viewed as undermining the fabric of what we are as Americans, are there laws that should be addressed outside of the campaign finance situation to address that, or do you not see that as a problem?
I don't see it as much of a problem. I am much more sympathetic to allowing foreign speech in the United States on policy issues. Where I draw the line is where the foreign national is actually assisting a campaign, such as being a speaker at a campaign event, being Elton John playing the piano to help raise money for the Clinton campaign, going door to door, active involvement in a campaign as opposed to simply articulating their ideas. And I am sort of a First Amendment free speech absolutist when it comes to pure political speech, which is what that is. I also am very skeptical that it's any kind of threat to our democracy to hear the views of foreign nationals. It is simply not, and I certainly hope we're not so weak as a country at this point, as a republic, that we can't tolerate different ideas coming from foreigners. So I have no problem with that whatsoever. I think it's dangerous to the First Amendment to actually restrict in one way or another foreign ideas and foreign speech. But there is a principled distinction between that and direct involvement in a campaign, interaction with the campaign, assistance to the campaign, which, by the way, in some cases could also be viewed as an in-kind contribution when it's not so easy to get Elton John to show up. That's a pretty valuable thing. So I might have argued that that's an in-kind contribution. The FEC saw it a little differently.
Secretary Adams, do you have a different view of that, of what kind of influence, apart from just the actual donations or contributions to a campaign, that foreign speech might be having on the freedoms that we enjoy in the country?
I do. I don't find it problematic if Elton John plays piano at a rally, primarily because we can see that he's doing it and it's obvious, it's disclosed, right? You don't need a FARA submission for that because we can watch him playing the piano. It's on TV, right? So I don't really find that to be an issue. I don't wish to ban foreigners from speaking in the United States. My issue is primarily one of disclosure. So that's why I'm so troubled by the obvious loopholes in our campaign finance laws that let these funds be contributed by non-citizens to support and oppose ballot referenda, to support and oppose indirectly, on occasion, campaigns for public office. That's the issue that I struggle with.
Okay. Judge, can I just very briefly address one point there, which is, we generally protect anonymous political speech by Americans, right? And there's a sort of a deeper issue here, and I think that's appropriate. And so I don't think it's appropriate to have sort of different disclosure standards for foreigners or for other speakers in the system. If you want to say that you want to know the identity of the speaker, that might make principled sense if you have the same concern within the United States. But generally, we are protective of anonymous speech, and in my view, that principle should be extended to any speaker.
Professor Zick, maybe we could come back to some of the comments you made. Some of that, the allegations that are being made are not that these visas are being restricted because of speech, but because of conduct, like vandalism and things like that. To the extent, I mean, you spent 9 days. Why don't you enlighten us on, are those overstated concerns by the administration? Are they, are they red herrings to get around what's really aimed at First Amendment rights?
Yeah, I don't know that they're red herring. So it's appropriate to look at conduct. And if the administration had done that and actually found someone whose conduct violated the law in the mix of students that they targeted and identified, we'd have a different conversation, right? Unlawful conduct is not protected by the First Amendment. Vandalism, as you say, assault, law breaking in general. But the fact of the matter is, and the cases involving these international students have gone through a process that's not the deportation process, but in habeas proceedings and bail hearings, each of them has one release in part based on a claim that the administration was retaliating against them solely for their expressive activity. And the administration, Secretary Rubio, among the officials say this, would say to courts, well, don't just believe what you read in the press. There's more. There's more. And that promise, at least as I sit here now, has not been realized. They haven't produced evidence that the students that they swept up were targeted, actually engaged in any unlawful conduct. The closest they came, for the protest on Columbia's campus, right, is that there were flyers that could be interpreted as supporting Hamas floating around or being circulated, but not by the student that they detained, arrested, and removed or attempting to remove. So I think my sense of how this policy was implemented was, and I have some sympathy for how the judge characterized it. It's very effective, right? If you are an international student, you are not going to be protesting anymore. And a lot of people say, well, good. Campuses aren't for protest anyway. And who are these folk coming here as visitors and guests and abusing that privilege? I think that's deeply problematic. I think if they had found people engaged in misconduct, A, you'd know it, and B, the record would bear it out. And after 9 days of trial and a pretty deep dive into these cases, it just didn't materialize. And I have to say, for the officials at the consular office and the State Department, they were troubled. So again, they've been ordered to do this. And as they're looking at these records, their memos and their notes on those memos indicate, I don't see anything here that isn't plausibly protected speech. I don't see any conduct in the writing of an op-ed that says to the university, change your view. So red herring, no. And, again, if the factual record was different, it's a very different conversation.
Okay. Well, and then I'll ask one final question, then we'll turn it over for the last few minutes to questions of the audience. But Professor Volek, to what degree would originalism play into this discussion? And I'm thinking specifically, maybe you have some more examples, like the Alien and Sedition Act. Is that something we could look back to? And to the degree that we can, how does that square with current First Amendment constitutional principles that seem to provide pretty robust rights?
So there are some things on which I think the original meaning of the freedom of speech and of the press can be pretty clearly understood. Things like, for example, symbolic expression was pretty clearly understood at the time as being tantamount to verbal expression, like was with pictorial expression. Civil liability for speech was pretty broadly understood as subject to constitutional constraints, even if the constraints were weaker than they are today. The freedom of the press was pretty broadly understood as covering everybody who used the printing press and not just some professional group called the press. There's actually a good deal of information on that. There isn't a lot on a lot of other questions. So, for example, with regard to foreign influence on American elections, I don't know of any originalist sources that tell us, like, would it have been seen as protected by the freedom of speech to accept money from somebody who's not a U.S. citizen in order to speak about a federal election? I mean, the elections were not regulated except with regard to outright bribery.
What role did Lafayette play in the first presidential election?
There you go. I think he was busy back in his home country at that point. So the Alien Act did not focus on questions of deportation based on speech as such. It just gave the government pretty broad powers to deport aliens. There was a big controversy about that, so it's an interesting question how much of a consensus there was about its soundness. But I just don't think there's a lot of data out there. Now, I haven't looked closely for it. Maybe there is. But I think part of the problem is, at least when it comes to originalism in the free speech, free press context, is a lot of regulations that we see today weren't around. There wasn't much of an opportunity for lawyers and others to talk about what would be permissible and what would not be permissible. So I just don't think we know a lot of it, or can know a lot.
Okay, well, we've got a few minutes left, and here we have a couple of questions. Go ahead.
I was saying countries like Hungary are my question. Foreign funding. What is your view of either law that would require closure reform?
Can I actually piggyback on that question and broaden it a little bit, because I think it's an excellent question. So recall 501c3s cannot speak out directly in favor or against a candidate. They also can't engage in substantial lobbying, including substantial backing of ballot measures. But they certainly can and do talk about issues, even in situations where they seem likely to affect politics. Of course, 501c3s and their kin are not just think tanks. At least two other important categories should be considered. One is universities. So indeed, this is one of the things we think about, but it doesn't just have to be kind of China, let's say, funding it. Again, lots of friendly countries may fund them, although we don't let even friendly countries' citizens contribute directly to election campaigns. And another kind of nonprofit is, of course, a religious institution. Many religious institutions get lots of foreign funding. And in fact, many religious institutions are subject to considerable foreign control. The Catholic Church is an example. I mean, I'm not saying that as a negative, but simply descriptively, the Catholic Church is indeed run by the Pope, who is now an American, but usually is not. So the Catholic Church, of course, again, can't engage in direct electioneering. And my sense is, generally doesn't get too involved even indirectly in elections, but could as to matters that are important, and in fact I think has spoken out with regard to matters that it sees as important, such as abortion and such. So to what extent would we say that if we are concerned about more than just electioneering, if we do want to broaden the things that kind of influence American public debate more broadly, to what extent should we impose similar restrictions on religious institutions getting money from foreign sources, as well as universities and think tanks? So that would be the question I want to pass along.
Okay.
No, but I want to
hear more.
Say.
Anybody else want to weigh in on this then?
So I think I'm the most restrictionist of all of us,
Yes.
which is not very restrictionist.
I was looking at you.
But so For myself, I draw a clear line between involvement in elections and everything else. I have no qualms. I want to keep FARA, but even then, I want to have the speech in our marketplace. I just want its origin to be disclosed. So I wouldn't go that far. Although I would know that the administration is tweaking policy on C3s, churches specifically, where now they're not going to be spending money doing IEs, but they can now make endorsements from the pulpit.
Right.
I don't find that as problematic if we're talking about where the funding is coming from. But it does kind of beg the question about if we're drawing a clear line of foreign funding and elections, does this kind of muddy that?
Right.
Yeah.
I would just add, you might keep in mind that Americans also fund think tanks, and we don't do very much about disclosure with respect to all the different special interests that might fund think tanks. So again, I think we have to think more broadly. Do we want different standards for foreigners or, the same?
Okay. We may have time. It looks like, sorry, we've got one more question. We'll go to this microphone now.
Thank you. Great panel. A question on free speech. I will direct it to Professor Volokh, but anyone can answer. Let's say the issue, I don't think, is about foreigners commenting on the wisdom of the 17th Amendment or the virtues of socialism or whether Donald Trump is a threat to the planet. It's more like, an example could be on September 12th or 18th of 2001, a Saudi Arabian student who's here temporarily says Osama bin Laden was misunderstood and he was justified in what he did. Should that person be deported? I mean, does the First Amendment protect that speech? I guess that's more, I think, what people are concerned about.
So I think there are two reasons to be concerned about foreign residents saying things like that. One is, these are bad ideas and we don't want them to spread these ideas. The other is, if this is what they believe, might they be trying to plan something else along those lines? And I think it's an interesting question. It's the same thing with regard to admissions. Like somebody's coming in and, you don't have proof that they're coming to commit terrorist acts, but they sure seem to sympathize with terrorist acts against the U.S. And why not just play it safe and make sure that whatever acts they plan, they have to plan from overseas. One interesting thing about the current debate about deportation is that the second element is largely absent, setting aside the concern about the possibility of disruptive protests and such. Even to the extent that you think some of these people, some of these students, for example, are supporting terrorism, they're supporting essentially violent action in a foreign country. This is a violent world we live in. And there's certainly, I do not at all endorse Hamas or their tactics, but the fact is there are lots of foreign disputes where people are using violence in order to try to achieve various ends. And even if we condemn that violence as terrorism, I think it's a legitimate question to ask, to what extent is it justifiable for one group to fight it out with another group in a foreign country using means that we think are improper, but they may say is the only way that they can accomplish their goals. So I think in the absence of this worry, they are people who might be a threat to us in a physical sense because they may be terrorist sympathizers who will actually commit terrorism in the U.S. And the only real concern is they are endorsing what we think is some monstrous foreign organization. But they're saying they're not monstrous. They're saying that Hamas is, let's assume, not all of them are. Some of them aren't even supporting Hamas. But even if they're saying Hamas is just doing what it takes in order for their people to win their country back, they can't afford to play by the Marquis of Queensberry rules. And that, it seems to me, is a debate that is an important debate to have. I'm pretty confident of the right answer there. But I don't think that there's such a compelling reason, again, in the absence of worry that this person is an actual threat of committing crimes in the U.S. I don't think there's a particular reason why we should be deporting people because their views about proper use of violence in foreign countries are different from ours.
Well, I know we have to disband, but I was wondering if a U.S. citizen said the same thing, it would be equally abhorrent, and the U.S. citizen might decide to actually join in on the jihad. I mean, I'm just wondering, so you are saying that there are instances where you can have First Amendment protections for citizens versus foreigners? I mean,
Yeah.
You're willing to make that line.
Right. My tentative sense is that indeed, in certain situations, especially when the speech is essentially evidence of this person's dangerousness, we can't kick out an American because we think he may be dangerous in the future. But maybe we should be able to sometimes kick out foreigners because we have good reason, even though not proof, that they'll be dangerous in the future. So I do think there's a difference between Americans and foreigners, but the question is, how far should it extend when the only concern is we just think that they're spreading bad ideas?
Okay, thank you.
All right. Well, we obviously could go on for longer. We've already gone a little bit over. Before we thank the panel, I was handed a note: do not open until after the conclusion of the panel. This is highly embargoed information. You're hearing it first. At 1:30 p.m., Justice Amy Coney Barrett will be signing copies of her new book, Listening to the Law. Copies will be for sale on the concourse level outside the cabinet room where the signing will occur, and that will conclude at approximately 3 p.m. So there you have it. And with that, can we get a good round of applause for our great panelists?